coming to you from my home office in Chicago, Illinois, and today I'll be talking to real estate agents and investors in regarding how to avoid deficiency judgments following a short sale. Now, when you have a seller or a client that's going through a short sale, a foreclosure, or even a deed in lieu process, the party's not really over for that seller, unfortunately. Each of these events can result in a deficiency judgment and a long-term debt obligation for the seller. Well, why? Well, the lender is taking a huge loss and may want to recover some of their losses by actually suing you. But keep in mind, there are several ways that you can avoid to pay back a deficiency. Now, please keep in mind, I'm not an attorney and I do not give legal advice, nor do I have any sort of legal background. So the information that I'm providing you today is just for that purpose. It's informational only. Now, ways that you can avoid to pay back a deficiency. Number one is negotiate a waiver of the lender's right to seek a deficiency judgment. Now, when you're negotiating with your lender for short sale approval, ask your lender to waive its right for deficiency judgment. If your lender agrees, then they'll provide that for you in your approval letter. What will your approval letter say? Well, it'll say something to the effect that this transaction is a full satisfaction of debt, and or maybe the lender might just put some sort of verbiage in your approval letter stating that this lender waives their right to deficiency. Number two, make a settlement offer. If your lender refuses to waive any sort of deficiency, you can offer to settle that deficiency for a small amount of cash. Now, if you do this, make sure that you have all of that on your HUD-1 settlement statement at closing, because we don't want anything to appear that the lender is getting any sort of illegal kickback. Now, a lender is likely to agree to a smaller amount because collecting a deficiency can be a very lengthy and costly process for the bank. So it's going to be a lot easier for the bank to accept a reduced lump sum than try to come after you for that full amount. And you can even negotiate to repay the bank that deficiency in installments over time through a promissory note. And a lot of times the promissory note, the banks will give you at 0% interest, which will help you through that process if that's the decision and the option that you decide to take. Number three, take the chance that your lender is not even going to actually sue you for deficiency. Now, after your short sale is completed, your lender may continue to call you, may continue to send you letters stating that you still owe them money, but these letters, they're going to either come from the attorney, from the collection agency, or from your lender, and they're going to be asking for basically demanding payment. Now, your lender or your collector may even intimidate you into making payments, but without any actual deficiency judgment being filed, the lender can't freeze your bank accounts, they can't garnish your wages, and they can't even place a judgment on any of the properties that you own. So to get a deficiency judgment, that lender actually has to file a lawsuit. And lawsuits are expensive, and most of the time borrowers who are forced to complete a short sale of their home to avoid a foreclosure are kind of judgment proof. And what I mean by that, it doesn't they don't have much in a way of cash reserves, because you're doing a short sale and you obviously are in financial ruin, so therefore you don't have money to pay this judgment off. Now, keep this in mind though, that a lender will only sue for deficiency judgment if the bank feels as though you as a seller or a homeowner have sufficient assets or funds sitting somewhere to pay that deficiency. If you can't afford to pay the deficiency, it's very possible that your lender is not going to bother with filing a lawsuit. And then of course, number four is to declare bankruptcy. Now, if your lender doesn't obtain a deficiency judgment, or does obtain a deficiency judgment, bankruptcy, like I said, is another option. But keeping in mind, from what I recall, Chapter 7 bankruptcy would totally discharge the deficiency, relieving you of all your debt, while a Chapter 13 bankruptcy would require you to pay a portion of that total amount of that deficiency that's owed. Now, bankruptcy might not be the best idea if the deficiency judgment is the only debt that you have. but it could be an option if you have multiple debts that you're trying to get rid of. And of course, to learn more about bankruptcy, you're going to need to contact an attorney. And remember, I'm not an attorney, and I'm not giving any sort of legal advice. And this information that I'm providing you today is just for educational purposes, and I hope that you find this very valuable. Thank you and have a great day.